future of the so-called Saf-T Act is likely to be decided in these Illinois Supreme Court races. As the public undoubtedly knows by now, the Saf-T Act passed in the early morning hours of January 13, 2021, after that 800-page bill was filed and we were given 1 hour to read it. While that bill has already had disastrous effects for law enforcement, the worst components of the Saf-T Act are yet to go into effect. That starts January 1st of 2023. And on this date, the state of Illinois is going to get a new bail system throughout the entire state. And this bail system will eliminate any use of cash bail. But more importantly, and disastrously, it's going to tie the hands of judges. It's going to prevent judges from making assessments on a charged defendant's risk to the public. This law, hamstringing prosecutors, judges, and law enforcement, will lead to violent felons being released. Violent offenders will slip through the cracks. Further, this law raises the standard on willful flight. And now a prosecutor, to show flight, must show that someone is planning to conceal oneself to evade prosecution. A very heightened standard, unlikely to be met. Failure to show up in court for any reason no longer will be evidence of avoiding prosecution or flight. Another component of the Saf-T Act that's already gone into effect is this 48-hour rule being gone from electronic home monitoring. As Cook County here uses electronic home monitoring to greater and greater effect in releasing charged individuals, they now get to skip out on electronic home monitoring for 48 hours before they can be charged with escape. Cutting one's bracelet off is not evidence of evading home monitoring. You have to be gone 48 hours. This has and continues to be a risk to public safety. All told, the Saf-T Act is going to lead to greater rates of recidivism and more crime throughout this state. Take a look at New York, and that's what you're going to see here throughout Illinois. Luckily, there are people fighting the Saf-T Act and its implementation. Sheriffs and state's attorneys, Democrats and Republicans in law enforcement have banded together and have filed multiple suits against the Saf-T Act, against Governor Pritzker and the Attorney General. Those lawsuits are now consolidated in Kane County under the case of Roe versus Raoul. We're very confident that if that lawsuit, if that litigation actually gets an independent hearing from the Illinois Supreme Court, their challenge will be granted, that the Saf-T Act will be struck down, and that issue will be returned to the legislature to ensure that we proceed going forward with the public's safety as a major component of any future change. However, the proponents of the Saf-T Act, Governor Pritzker, and the leaders in the Democratic majorities in the House and the Senate have been significant campaign contributors to both Justice O'Brien and Judge Rochford. It is certainly reasonable to ask the voters of the 2nd and 3rd districts of the Illinois Supreme Court, based upon the large, substantial financial backing Justice O'Brien and Judge Rochford have seen from the champions of the Saf-T Act, will their concerns for their own public safety be given fair consideration by the judge and justice in litigation like the challenge in Roe, as this is going to be decided ultimately by who we elect in the Illinois Supreme Court races.